This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. I'm Catherine Eaton, a collaborative family law attorney and a member of the Florida Academy of Collaborative Professionals. Today's guest is Matthew Thatcher. Matthew is a partner at the Solomon Law Group. He's been board certified in marital and family law by the Florida Bar since 2009. And he attended his first introductory collaborative training in 2016. And he currently is serving as one of the co-chairs for the Next Generation Divorce Collaborative Group in Tampa. So thank you for being here.
My pleasure. Thank you for having me.
Can you please tell us how you got involved in the collaborative process? Seems like every guest that we have, they found out about the collaborative process in a different way. So I'm interested to know how you started practicing collaborative and how you learned about it.
I learned about it from other attorneys and other professionals. As you said earlier, I've been practicing for a long time. I've been licensed since '98, board certified since 2009, and mainly in family law. And I've had multiple lawyers and people, mediators and mental health people over the years telling me after mediations and cases, you should become collaboratively trained. You're resolving this case in a collaborative manner. But I had never heard of collaborative beforehand. I'd never done the training. And I had enough people tell me that you think collaboratively, you're resolving your cases in a collaborative manner, that I decided to go ahead and take the plunge and take the introductory training and really learn about what they're talking about and realize that, yes, I actually had been working my cases in that kind of problem-solving manner to move things forward for the clients rather than just blow them up for the sake of litigation.
Will you explain to our audience a little bit about that style? So somebody saw that in you, you took the course, you said, yeah, that's how it should be done. That comes naturally to me. What is the difference with that style and collaborative versus if you are litigating?
It's really true problem solving rather than winning and losing. And nobody really wins and loses in a divorce case. And it's not like a personal injury case where the jury returns a verdict and somebody wins and somebody has to pay money. In a divorce case, there's too many moving pieces. And you have to look at the whole family and the dynamic, because these people are going to have some kind of a relationship going forward. If they've got children, even if they don't have children, you don't want to leave them broken. And so my goal had always been to try to find a way to resolve whatever these issues were with the clients presented in a way that was most expedient, that made the most sense. And sometimes you can get what you want and I can get what I want, and we both can be happy, rather than I get everything that I want, you get nothing that you want. And I feel like that never felt fair. It never felt right. And a lot of times in litigation, it's all or nothing. And with collaborative and with some of the mediation that I was doing that led up to the collaborative process, it was a lot of recognizing that I can give on things, or my client can give on things that were of lesser importance to them, but were of greater importance to the other side, and both parties could walk out feeling like they had a fair deal and they got something.
Can you give an example then of that, like that one person is, as we say, interest-based, it's really important to them, and it's not so important to the other person. So how can that work, that both people are getting basically what they want and resolving these issues?
Let's say you have use my own case, because I'm divorced. My child is currently 20, so I'm still co-parenting, but on a whole different level with college. But my situation was interfaith. I'm Christian, my ex-wife was Jewish. And we both, for her, Hanukkah was important and Passover was important. For me, Easter and Christmas were important. We both could get our respective holidays and both went. And it wasn't that she had to have Christmas and I alternated every year, because really Christmas wasn't important to her. That wasn't what she cared about. I didn't care about the Passover Seder, but it was important to her. So we were able to find a way that we could both share with our daughter the stuff that was important to us, and we both won and our daughter won.
That's
Whereas
a
in
great example.
litigation, you're going to end up with a situation where the default parenting plan is going to be, this is the holiday, in even years you get it, in odd years the other person gets it. And in that way, nobody wins.
And when people are in the collaborative process, can you explain a little bit how that transpires? What's the style? I mean, people are used to seeing trials, on TV, whether it's a movie or the news, so they know that there's a judge and there's an attorney on each side, and they're used to seeing kind of what would happen if they went to trial, but people don't, there's no movies and television about the collaborative process, so people are just envisioning it. They've never seen it. Can you describe what takes place?
It's really, it is a empowered conversation between the two spouses. In the courtroom, the lawyer is the lead person, the lead dog. The client defers to the lawyer to determine what our strategy is, what is most important, where are we going. But in collaborative, the lawyer really has to take a back seat. And it's the clients who drive it. And you kind of envision like that we're all sitting at a table, we're having a conversation about what's really important to us. And what do you envision your future to be, and what security needs do you have, and what things do you want to have addressed? You've got the facilitator who's guiding the process, who's not the lawyer for either party, so there's no power imbalance. And the lawyers are kind of off to the side, offering advice and guidance, kind of like angels on wings, but they're not really the ones who are giving the opening statements and setting the positions and laying out the track that we all have to follow. It is the people whose lives are being directly affected who are the ones being empowered to do that.
I like that. I like that analogy and that description. It's actually the parties who are doing the talking, while instead of the lawyers who do all the talking in court. You're right. It's the parties who are doing the talking, and the facilitator is moving those conversations along.
And every now and again, the parties may get stuck, and that's when the two lawyers or the other professionals will chime in with suggestions. And the neat thing, the fun thing about collaborative is you have the freedom to offer advice that may go both ways. So there are some solutions that may benefit the other spouse more so than your client, but it moves the process forward, and you're throwing out as many options as possible. Whereas in traditional litigation, there may be a fantastic option, but if it doesn't truly benefit your client, you're not going to voice it. You're only going to voice the ones that benefit your client. And it, I think, benefits the parties when they hear the husband's attorney say something that is helpful to the wife's understanding, or vice versa. Let everybody know that we're all really in this for the common goal of you finding a good solution, rather than one side getting the upper hand on the other, or one side, quote unquote, winning.
It is a team approach, which is very different from one side versus the other side. Will you talk a little bit about why you think a facilitator, I mean, because under the statute, you can have a collaborative case with each party has an attorney. It's not required to have a facilitator or a financial neutral, but a lot of people choose to have one. Can you talk about the importance of the facilitator and how you think that helps move the process along?
Oh, absolutely. Optics is critical. And whether the facilitator is the mental health person, I've actually been involved in a case where, for economic reasons, the mental health facilitator was asked to step out when they resolved parenting, and it was the financial neutral who came in and facilitated the team meetings. You need to have somebody other than the husband's lawyer or the wife's lawyer to kind of push the agenda forward and guide that conversation, because no matter how collaborative the two professionals are, it ultimately comes down to the perception of the parties. And if, just personality wise, one party's lawyer is taking more of the lead in the conversation, even if it's a scripted arrangement that the two lawyers came up with in the pre-meeting, the parties may feel that like husband's lawyer, wife's lawyer really is dominating or controlling or dictating where we're going, and you're losing that true perception of neutrality, perception of a team approach. The lawyers really have to be stepped back, and the perception of the parties has to be that they're even in terms of their role in this. And if one lawyer is more prevalent than the other, I've always been concerned that that may be the beginning of a road towards the collapse of the case.
Yes. And you're right. The lawyers really have to step back and let the parties have the conversation and resolve the issues. And we're just there for ideas. And can you talk a little bit about ideas and option building and how that process works? You touched on it a little bit about how one attorney could give an idea that would benefit the other spouse.
Mm-hmm. Well, in litigation, it's positions. I want this, you want that. In collaborative, it's how can we do something? And there's 100 different ways and roads and avenues to get to the end point. And it's throwing out those different alternative ways to approach it. And I tell my clients, the only limitation on what we can do ultimately is our creativity. And there may be some unique approach to resolving a problem that these people face that maybe we've never done in a case beforehand. But if it works for this family and they're good with it, then that's something we can try. But we throw out all of these things to give them like a buffet of potential paths to reach their resolution. And it can be, let's say you got a business, and maybe one option is that they remain business owners if they're able to do that, or maybe they hire somebody to run the business, or maybe they sell the business, or maybe somebody buys the other person out of the business. Those are all different options, and we lay that out on the table without saying that we prefer one or the other. They're all of equal value for the professionals, but we give them these things to pick from and make sure they're fully informed, and then they can be the masters of their destiny resolving the case.
So many people hear that collaborative, it's that the parties sign an agreement and they promise that they're not going to go to court, but that's just one part of it. But what you're describing is the process of how, if you go through that process, you're going to resolve it and you're not going to end up in court. So, and you talked about having an agenda. So can you, I mean, for people who aren't used to, they don't have agendas in their profession, or they're just not even sure what would be on the agenda. Can you talk about how the agenda and works in the collaborative process?
The way it works, at least in the cases that I've been involved in, is it helps keep everybody on task. We, the professionals in advance, come up with, these are the things that we are going to be dealing with at this particular team meeting. You don't want it to be a free-for-all where like we go in 15 or 30 different directions and ultimately nothing gets resolved. So in advance, it's decided that the next meeting, we're going to talk about the parenting plan or issues with the parenting plan. Maybe the parties are trying to figure out how to handle school pickups and school drop-offs. But we put that on the agenda. We send that out in advance so that they know what we're going to be talking about. And we show up for the meeting, and we only deal with the stuff that's on the agenda. I mean, there may be a pop-up here or there that's pressing, that's got to at least be touched. But by keeping it, by having an agenda that everybody knows that this is what we're going to be talking about, by sticking to it, it moves the process along faster because everything stays more focused and organized, and everybody knows what to expect. And sometimes it keeps the cost down because if, let's say, we're going to be dealing with parenting issues, the financial professional doesn't have to be present.
And in your experience, and I know it really varies, but how long does the collaborative process take for parties to, after they decide, they have their consult with their attorney and then the professional team is brought together? How long does it usually take? How many meetings are you finding that it takes for people to resolve?
I mean, ultimately depends upon the issues involved. I've got a case going currently, and it's going to go a little longer, but it's because we have to have other work done by outside professionals, and that's going to delay us because we have to wait for those things to report back to us. But normally, if everybody is giving the financial information to the financial professional and everything can get turned over rather quickly, I don't know why you couldn't resolve a case within 4 to 6 meetings.
That's what I'm hearing too, but I always like to check in and find out how it's going throughout the state for everyone else. But I agree with you that, and again, it just depends upon the issues to be resolved, whether or not there are minor children and you have to work on a parenting plan, and what the party's finances, if they have a business, or what their finances are. What's your favorite thing about the collaborative process?
The resolution, because the judges love it. And you go in and you do the uncontested, because even when you're in collaborative, you still have to go to court and have to prove up the final judgment and get the divorce granted. I mean, you still have a little bit of a court process, but you go in and the judges are just ecstatic to see it. You go in, you tell the judge, we're here, this is the collaborative case, and you see the smile across the bench. And they know that this is an agreement that the parties will be happy with. This is something that's more than likely not going to return back for future problems. There are a lot of the judges out there that are starting to push and encourage people to do collaborative because it reduces the conflict that they have to deal with the cases that have just spiraled out of control. And it's neat to go do those. And a lot of times, if let's say everybody goes, the whole team goes and both parties go, it's not it's an ending of the marriage, but it's still kind of it's now more of a beginning of their life going forward with this new thing that we've created. And it's a neat ceremony to go to, as opposed to your standard final hearing.
So if someone's listening to this podcast and they said, you know what, the collaborative process is, it sounds like it's a good option for my situation, and they find a collaboratively trained attorney, do you have any suggestions on how they can approach their spouse or soon to be ex on that the collaborative process is something to consider?
They can just sit them down and talk to them about why they would like to do the collaborative process. They can refer them to, I mean, a lot of the practice groups have information on their websites that are available that talk about collaborative. There's things like this, the podcast that we're doing here, that provide information. I've even seen situations where, like, what I've done sometimes is I would send a letter to the other spouse before the divorce is actually filed, because a lot of collaborative cases are pre-suit with just, I represent so and so, we would like to resolve this collaboratively, and here is a referral towards the website of the 2 other local practice groups. Here are potential collaborative professionals to go talk to. We encourage you to go do that. We would like to find an amicable way to resolve this case. I mean, sometimes it just comes down to knowing your spouse. And I'll ask my clients, what do you think is the best way to approach them? And let's try to go that way.
That's a good idea. And I like the letter giving the other side information so they can explore it on their own, whether they go to, a local practice group or to the FACP to get more information. So thank you. That's good advice. Is there anything else that you'd like to add to about the collaborative process? It seems like we've touched on a lot of it. We touched how it works, and agendas and facilitators, and how to find out more information.
Yeah, I'd like to add that it's not too late. There's a perception that you have to do collaborative pre-suit, and that if the one party has served the other with a petition for divorce, that it's too late. And that's not the case. You can always pull a case back from the brink and turn it collaborative if everybody's willing to do so. There's administrative orders in the different circuits that allow a case to be abated while you do this. You just have to follow the law, sign the participation agreement, and go through the normal processes. But don't think because my spouse filed first and didn't know about collaborative, that this is not an option. This is always an option that you can choose up to the point that you're basically on the eve of trial and you're stuck showing up and arguing in front of the judge.
That's important to know. So thank you for that.
My pleasure.
Thank you for being a guest today.
Thank you for having me.